Member for Brennan.
Thank you, Madam Speaker. Madam Speaker, we stand in solidarity with the community and the Fyke family, a family who last week had their husband, father, brother, uncle taken from them tragically and too soon. Territorians have every right to feel heartbroken, frustrated, to feel angry, to be grieving of these recent tragic events. I want to acknowledge Samara Laverty in the chamber today. She has courageously fought for Declan's Law for the last 2 years in the hope that she could spare anyone else from going through the horrendous and unbearable pain that she continues to live with. And Samara, I thank you for returning to Darwin to support our community at this time. I know it's a huge emotional investment for you and for your family, and I thank you for assisting us with not only Declan's Law last year, but also with the information to help us with these new laws. Madam Speaker, our government is acting urgently to ensure that community safety is the #1 priority. This is why we are here today. The Chief Minister recalled Parliament urgently to build upon Declan's Law and make our bail laws the strongest in the country. Madam Speaker, within 8 weeks of coming to government last year, the CLP introduced major law and order reforms, including Declan's Law, which was stronger bail laws, and knife wanding powers. And Declan's Law has contributed to having more than 600 extra prisoners. They were already in the system since these reforms began. Knife wanding operations have scanned more than 5,000 individuals since being introduced. We introduced mandatory sentencing for assaults on workers. We reinstated breach of bail as an offence for youths. Public drinking laws were strengthened with over 227 fines issued. Post and boast legislation had already 10 individuals charged with those new laws. The ram raid legislation we introduced has already had 19 youths charged and 5 adult offenders charged under that new offence. The pace at which we introduced and passed all of these new laws upon coming to government was unprecedented. Declan's Law introduced a presumption against bail for serious violent offences, mandatory electronic monitoring for repeat offenders, expanded the presumption against bail to apply for youths, and reinstated breach of bail as an offence for youth offenders. Madam Speaker, we've always known that there was more work to be done, and especially after that first crime package that we introduced just 8 weeks after coming to government. We were already working on the Youth Justice Act rewrite and the Bail Act rewrite. However, after the recent tragedy and community frustration, anger and grief, and of course being fed up, we brought forward the changes that we thought could have the biggest impact. We know the types of violent offending that is happening across the territory isn't limited to the tragic events of last week. There are many victims of violent offending, which is not acceptable. We know this, and that's why the Chief Minister recalled Parliament urgently and quickly to introduce new laws to respond urgently to community expectations. And Madam Speaker, you would know that recalling Parliament urgently is not a decision taken lightly. In fact, I remember in the previous 8 years under the Labor governments, despite community pressures, Parliament was not recalled urgently to deal with the crime crisis, and nor was any meaningful new legislation brought in by Labor back then to keep serious violent offenders off our streets. Madam Speaker, make no mistake, for those who place the historical trauma of offenders before the rights of victims or the rights of offenders, that ideology is why we are seeing such acts in our community. and our CLP government has been very clear for a very long time that we will put the rights of victims and the community above the rights of offenders. And if that means that violent offenders are sitting in a watch house or prison, then so be it. That means that they are not out on our streets able to commit more crimes. The new reforms will maintain Declan's law for the presumption against bail for serious violent offences or repeat offences, and all of the conditions in Section 24 that must be considered. This means the offender must convince the decision maker, being either the police or the courts, why they should be granted bail. If they manage to convince the decision maker they have mounted a good case, then 2 new tests under these new bail laws must be applied. The first test makes community safety the paramount or overarching consideration in all bail decisions. Then, even if the decision maker still thinks the community will be safe and bail is granted or consideration of granted, a third test must apply, which is where the decision maker now asks themselves and has to answer themselves that they are satisfied to a high degree of confidence that the accused won't offend again or endanger the safety of the community if bail is granted. These 3 tests applied will now be the strongest and the toughest in the country. The amendments to the Act as a whole strengthen the presumption against bail and reinforces that the starting point is that there is no bail for serious offending. They are modelled off the current strongest laws in Australia, which is the New South Wales bail laws. However, the Territory and our government will go even further. And it's further because our new laws applies to a broader range and a much longer list of serious and prescribed offences. It also applies equally to youths and adult offenders. In New South Wales, it doesn't apply to adults. And it ensures that community safety over offender rights and a high degree of certainty regarding community safety and risk of reoffending. In addition, these new tests create consistency between adult and youth bail tests and also consistency in the way decision-making occurs by police and the courts. Madam Speaker, these amendments also removes the detention as a last resort principle for youth bail matters and removes the court's ability to consider the need to minimise the stigma to a youth resulting from being remanded in custody. And I note the Leader of the Opposition said she didn't hear about this until she's seen the bill, and yet it was covered off in great detail in the briefing yesterday. This was an original recommendation to include this clause of the detention as last resort, original recommendation from the Royal Commission into Protection and Detention of Children, which occurred 8 years ago. The implementation of those law change recommendations ultimately led to the watering down of bail and youth laws, with the rights of offending youths put well above the rights of community. And for some offenders who are now adults, 8 years later, they were youths when these laws began, when they began being watered down. And they may never have had consequences for their crimes. Some of these crimes are serious and violent. And given that the principle applied to bail was that detention should be the last resort, means that it was very rare for a youth to be remanded, even if the crime was so serious and so heinous and so violent. So we are removing that principle in this legislation. Madam Speaker, I want to pick up on a couple of the areas that the Leader of the Opposition talked about in her address to Parliament today. She talked about the remand pressures and how there are so many people on remand sitting in watch houses and our prison system. And we absolutely acknowledge as a government that it is an imperfect system. It's an inherited mess that we came in just a short few months ago. I think it's now 9 months. And a lot of work has been done in that time, Madam Speaker. There has been the Corrections Master Plan, where new beds are being found every single week right across the Territory to ensure that there are places that people go if they're not granted bail and they need to be remanded. Because we will put community safety as everyone's priority. The Leader of the Opposition talked about the average time that a case sits in the courts, and I think she may have referred to a figure in the Supreme Courts, and I have that data in front of me. And it's interesting that she has such a short memory, considering she was a minister for a long time in the previous Labor government. In fact, she was the Attorney General, so she'd be well aware of these numbers. In 2019, Madam Speaker, the average time of someone sitting in remand at the Supreme Court was 275 days. In 2020, still well under Labor, that grew to 302 days. In 2021, it grew to 401 days. In 22, it grew again to 419 days. In 23, it grew again to 458 days. All of this under a Labor government watch. In 24, which is the year we came to government, it dropped slightly by 2 days to 456 days. And then in 25, the stats we have is 453 days. So as you can hear from those stats, it used to be lower. It increased over time, and then we've started to try and turn that tide because we want to invest in the justice system. We've seen 8 years of Labor who didn't invest in the justice system. In fact, they believed that jailing was failing. We don't agree with that. We think people who are violent offenders are either going to be out in the streets committing crimes or they need to be in prison. There's no special other place that they can go to. And Madam Speaker, in just the last few months, we have invested in our justice system. We appointed an additional full-time local court judge and more court staff, which actually means now we will be the largest judicial complement that we have ever had in the Territory. It means we have more people working in that system than ever before. We recruited 4 new prosecutors and additional support staff because we needed to boost the prosecution capacity. There were 20 DPP staff who were on temporary casual contracts for years. We've now made them permanent because we need them to stay here and we need them to assist with the justice system rather than worrying about retraining people as they come through. And Madam Speaker, something that was absolutely critical in what we've done in just a few short months coming to government is we launched the Targeted Intervention Group Early Resolution Task Force. We called it the Tiger Team for short. I know everyone loves an acronym. But it's a team within the Department of Prosecutions where they look at all of the cases and they fast-track remand cases. I mean, this work has never been done before. It reduces court backlogs, and we've already, since the end of January, finalised 200 cases. Madam Speaker, of those cases, the Tiger team in the DPP have reviewed 290 remand cases, finalising 213 of them, including 87 of them being guilty pleas, and they work with the prosecutors, the defence and the police to ensure all the information is there so they can work out these early pleas, which brings the system forward. It means that justice could be served quicker. All those people in remand who are innocent can be dealt with as well. Madam Speaker, when we were going through this, we actually found one case that had sat in the system since March 2024. This team picked that up and they were able to resolve it in just one day. And this team has only been working since the end of January. So that backlog of cases that have been there for such a long time, I mean, years and years, and the reasons why there are so many days of people sitting on remand, I mean, this is being worked on now. It has never been worked on like this before. This is true change, true reform, and true investment into a justice system which literally sits in the middle of police and corrections. And that's why it's so important, and that's why we will make those changes, and we won't stop there. This is just the beginning. Madam Speaker, I also want to touch on the fact that the Leader of the Opposition talked about alternatives to custody. And she was saying that we need to invest in those, and there are a couple already set up, and I agree that they are, and I've seen them. But we haven't, what we haven't seen in 8 years of Labor was that they actually assigned any investment to those programs, to those facilities. I mean, they were very expensive to run. The investment going forward just wasn't there. And if you think about the state of our economy, which we all know too well that it's in, we have to prioritise the funds. And so at the moment, we have to get these violent offenders off our streets. They have to be dealt with the courts. They have to be on bail if that's what if they can't live out in the streets and keep our community safe, then they need to be behind bars. And so that's where the investment is going right now. And of course, we believe in rehabilitation. We believe in having to find better ways so that these people can be educated and have the right behavioural change programs so they can go off and lead a life beyond crime. But we're just not at that point. And that's why we've had to invest in the front end of everything, which we are doing, because that is the priority. But I also acknowledge that there was a bit of an attack on our not addressing the root causes and how we have to have investment in those spaces. But Madam Speaker, we're doing that at the same time. I mean, we have our Education Minister and our Minister for Children and Families who have worked tirelessly with their teams to stand up a bunch of things that we have been successful in. I mean, our Education Minister has truancy officers right throughout the Territory now, talking to students about getting back to school, talking to parents and making sure that if they don't send their kids to school that there will be fines, and that is working. We do actually have more kids in schools now, and that's what we need to break the cycle, to address the root causes, is to get these kids educated. The circuit breaker program that the Minister for Children and Families is working on, I mean, that has been a fantastic start, and that's all it is as a start. There's been 120 cases that have been worked on across the Territory. The parental responsibility agreements are now actually happening. I remember sitting here for 4 years as an opposition listening to the Minister for Territory Families back then talk about family responsibility agreements, but none of them had ever actually been done. It was just all talk. We now have a minister who's doing that, and there's been 75 agreements already signed up. That's 75 families involved in these kids where they are addressing those root causes and ensuring that they're not going to grow up to be adult criminals. And I think that's absolutely fantastic. And this is just the start. Madam Speaker, remember, we've been in government about 8 months. 8 months. We're already here recalling Parliament again because this is so urgent. This is how important community safety is to us. It's not only our government's priority, it's not only the community's priority, but now it's everyone within the justice system's priority, because we are enshrining into legislation that those tests that everyone has to adhere to as decision makers in the courts and in police must put community safety as a priority and must satisfy themselves to a very high degree of confidence that that offender is not going to go out into our community and endanger the community, or that they're not going to reoffend. That is the highest test and threshold in the country. Madam Speaker, that's why this bill places community safety at the heart of our bail system. Like I said, it's what our community expects. I think it's what they deserve, and everyone knows that to be true. I stand in support of our community and our government in bringing forward these important law and order reforms. I extend my deepest condolence to the Fyke family. And I thank Samara Lavity again for being here today to support the community. As the Corrections Minister mentioned, the departments that had been both in Parliamentary Council and Attorney General's Department have literally been working day and night this week to bring this forward urgently, and I thank them greatly. It's a lot of work that needs to be done, and they have done an exceptional job. I also thank all of the police and those that were on the front line that dreadful day last week, and just know that we support you as well, because the work you do is absolutely thankless. There's really nothing we can say that can show our gratitude for that. And of course, I can't go without saying thank you to corrections as well, because you know what? It's going to be tough. We've got a tough couple of months coming up once this is implemented, and it's, you know, it's imperfect, and we absolutely acknowledge that. So in advance, I want to say thank you to corrections and the police and our systems, court systems. We will get through this. We've been through this before at the end of last year, and we will do it again. We are much better prepared this time because we've already been through it. Many systems have been stood up, and we've been able to work through that together. And as a government, we will continue to do that work. So thank you, Madam Speaker, and I commend this bill to the House.